Hello, everyone, and welcome to the UAE In-House Community eCongress 2021. My name is Rahul Prakash, and I'm the publisher at In-House Community. A huge gratitude and thanks to our co-hosts for the Congress, namely Al-Suwaidi and Company, AMERELLER, Gibson, Dunn, and Hardeep and Partners. The UAE In-House Community Congress will take place over 3 days, and the first day is today. In the next 2 hours or so, you'll be hearing from Ali Kassam and Hardeep Plahe from Gibson, Dunn, who will be talking about navigating financial distress. After their presentation, we will have Jonathan Noble from AMERELLER presenting on employment law in the UAE. Now, the second day of the UAE In-House Community Congress will take place on the 27th September, which is a Monday. It'll take place from 3 p.m. to 5:10 p.m. or so, and lawyers from Al-Suwaidi and Company will be speaking on anti-money laundering and dispute resolution in the UAE as the first panel discussion on that day. And right after that, we'll have another panel discussion, which will be a GC and partner discussion on diversity, equality, and inclusion, as well as mental well-being. And our third and the last day of the UAE In-House E-Congress will be on the 4th of October, which is a Monday, from 3 p.m. to 4:10 p.m. It'll be the only presentation on the day as of now. And the presentation will be about UAE intellectual property, and it will be presented by lawyers from Hardeep and Partners. We'll be introducing these presenters on the day in detail. Now, a quick word about In-House Community. We'd like to welcome all the In-House Counsel who've joined us, who have participated in our previous In-House Community events, in-person events. Unfortunately, this year we couldn't do an in-person event, but we welcome you all and also welcome any new In-House Counsel. In-House Community, it's our mission to empower and educate In-House Counsel for the benefit of all. We have over 17,000 members all together along the Silk Road, the new Silk Road you can see in the map on the slide. We also are the publishers of In-House Community magazine, which replaces Asian MENA Council magazine. Now, before we start our event, I'd like to make some quick housekeeping notes. There will naturally be an opportunity to ask questions during the presentations. To ask any questions, please type them into the Q&A button or Q&A box on the webinar interface. It might be either to your right or at the bottom of the Zoom panel. You can type the questions there, and I'll personally make sure that the presenters today see those questions and reply to them if they can during their presentation time slot. Also, we'll have some poll questions during the presentation. You'll be shown these questions on your screen, and you can answer them using your mouse. They'll be on your screen, and we'll share the results of the poll for the presenters to comment on. The presenters may also ask you, this is very important, they may also ask you open-ended questions, and you can reply to them in the chat box or in the chat function. Also, we will not be providing any copy of the slides directly to you. However, if you need a copy of the slides of any of today's presenters, or if you have any further questions that you would like to get answers of, then you can email the presenters or call them directly. Their information, the contact information, will be shared in the chat box with you all. Also, there will be a very short survey at the end of the webinar today. Please make sure that you do fill in this questionnaire. It's a very short questionnaire, but it's extremely useful for us to keep putting these events together for you. Now, without further ado, I'd like to invite the speakers of our first presentation today, which is on navigating financial distress, which will be presented by, firstly, Ali Kassam, who is the partner at Gibson, Dunn. Hi, Ali, how are you?
Hi, how are you?
So Ali has experience across a broad spectrum of debt capital structures, including senior mezzanine, bank, bond, and bridge financing. Firstly and secondly in special situation loans and asset-backed loans. He focuses his practice on cross-border banking and financial transactions, including leverage financing, Islamic financing, and special situations lending and restructuring. And next, I'd like to invite Hardeep Plahe, who's also a partner at Gibson Dunn. Hardeep, you can turn your webcam on. Hi, good to see you.
Good to see you too.
So with a broad and deep knowledge of the Middle East business landscape, Hardeep has helped clients navigate their way through some of the most complex and important transactions in the UK, continental Europe, and the Middle East. He advises private equity clients, financial institutions, corporates, sovereign wealth funds, and government. So thank you very much, Ali and Hardeep. The stage is all yours. You can start sharing your screens. Thank you.
Hello. Ali, shall I do the
please.
intro? Hello and welcome to the IHC. It's a shame that we can't see everyone in person this year, but for those who are serial attendees of the IHC, you will know that Gibson Dunn does certainly try to do these events and provide useful content for most of the last, I think certainly 7 or 8 years at the IHC. So we're welcoming again the opportunity to do this, but this time on a different subject. For those who don't know us, if I may, I'm going to provide a little bit of an introduction to Gibson Dunn, and then myself and Ali will do the same thing, and then we'll get into the subject matter proper. So Gibson Dunn is a very large global law firm. We have over 1,500 lawyers around the world, spanning 20 offices. We started out life back in 1890 in the US, in the West, in Los Angeles, and grew from there, and now have 10 of our offices in the States, 10 of our offices outside in the global financial centers. In terms of where we don't have an office, we have great relationships with local council, and the key that we have in terms of differentiating ourselves is that what we try and do is do the things that we're very good at. So what are we good at? We're good at strategic advice when it comes to legal matters and beyond. We have and bring an international perspective to your transactions and disputes. And we like to think that we provide innovative solutions to those things. Now, it's also important with any law firm to understand what they don't do that well, or what they don't concentrate on. And we're very open with our clients, certainly, that we will generally leave the experts in certain local jurisdictions to provide their advice, and we will steer clients through that advice in a sort of the wider context of the transaction or the litigation or other dispute that we're helping our clients with. So that's what we do. In the Middle East, we are based here in Dubai. But we do cover the main financial and industrial centers. So places like Abu Dhabi, Saudi Arabia, and the rest of the GCC is covered out of our Dubai office. We have a number of practices. Transactional is M&A, finance, which Ali's part of, fund formation, and then of course what we also have is the disputes side of things as well. So when you're talking to your Gibson Dunn lawyers and your Gibson Dunn partners, I think oftentimes it just helps not to come to us with a problem which fits within a particular practice area, but just come to us with your problem, and we will try and help, because I've been in the region for well over 15 years, and most of my partners have similar backgrounds in terms of longevity. So that's a little bit about me and the firm. Let me hand over to Ali, who can give you some information about himself, and then we can get into the information of this presentation proper.
Thanks, Hardeep. I'm Ali Kassam. I'm partner in the banking and finance practice of Gibson Dunn. As a result of where the market has gone over the last 5 to 10 years, having started off as a finance lawyer, I now wear 2 hats, and I'm a finance lawyer and also a restructuring lawyer. So therefore, I can help you to put the money in, and if things go wrong, we can help you with what to do if things go wrong, which leads us into this presentation neatly. Unfortunately, over the last few years, we have seen an increase in the number of companies that have faced financial distress, particularly in this region. And one of the things that we have noticed is that the management of those companies often have not experienced those situations before, given that there's been a sort of series of growth in this region for a number of years. And as a result, once there is financial difficulty, there's a lot of panic and a lot of concern as to what to do and how to manage that financial distress. So what we'd like to cover over the course of this presentation is what your options are as a company in financial distress, what the big concerns for management are, conscious that there are a lot of people who form part of the management of the companies on this call, some do's and don'ts for the management, and the consequences which might apply to managers if they do engage in what I'm going to call bad acts. And then as we go through the presentation, we will pepper in a few practical tips that we've seen from transactions that we've been working on over the last few years. So the first slide that we're going to talk about is what your options are in financial distress. And we've sort of laid this out in pretty plain vanilla terms, being option A, you raise capital and maintain the company as a going concern, including by way of equity injections or debt raise options. Option B, you wind down the company on a solvent basis. And then the stark consequence, which is if you don't choose either of these options, the company might need to go through a corporate insolvency process. And what I'll do is I'll pause there and we can talk a little bit about option A being the simplest route for most companies, which is how do we fix our underlying problems? And I'll hand over to Hardeep to talk about equity solutions to fixing the underlying problems.
Yeah, thanks, Ali. So what are we saying when we're talking about equity solutions? What we're really asking is for shareholders to go into their pockets and inject further capital into the company. Now that sounds like a fairly simple fix, but it's often a question of whether the shareholders are willing to put more money into a company which they have already invested in. And there's no one size fits all type solution here, because we may be dealing with a company which is owned by one person, one company, one family. It may be a public company. It may be a company which is owned by way of a joint venture, so 3 or 4 shareholders, none of which have a controlling stake. And so what you're really trying to do is deal with the investment objectives and appetites of the shareholders, and each of the shareholders at that particular stage in when they're being asked to put money into the company. And that can be quite a fraught process that Ali and I have dealt with a number of times, and quite recently as well. So that's your basic getting money into the company by way of an equity injection and issuing more shares to your shareholders. Now, there might also be a scenario where shareholders are not willing to do that. And if they're not willing to do that, we've also found situations where the shareholders say, or one shareholder says, look, I think I've had enough. But I do know someone who wants to have exposure to this business and thinks that they can run it in a better way, or has deeper pockets, and so on. And what does that turn into? That turns into an equity injection coupled with an M&A transaction. So essentially what you're trying to do is you're saying that the old shareholder is going to get out, or a number of those shareholders are going to get out, a new shareholder is going to come in, and the trick there is to ensure that a company which is already going through distress survives that process, and is able to support that transaction as it goes through, which is oftentimes a process that takes many months, and various stakeholders have to be on side for those sorts of transactions to become successful. Not only management, but other stakeholders, banks, your other shareholders, if there are any other shareholders as well. And in the meantime, what people often forget, is that the business needs to keep running, and the key shareholders in businesses are the customers. So that if the customers get a whiff that there is a company which is in distress, they may turn away from that company, delivering further stress on the business. So I think there's a lot to be unpacked there, but I'll leave it there and hand over to Ali, who can talk about the what happens on the debt side.
Sure. So the other option in option A is, if you don't put equity in, you can put debt in. Now, debt can come in any form of vehicle. It can be a sort of standard loan from a bank. It can be debt from your shareholders. So your shareholders might choose, rather than increasing their equity stake, they're going to put debt into the company by way of a loan or by way of preference shares, or you could structure that debt insertion into the company in a number of different ways. But fundamentally, what it does is it adds more debt to the balance sheet of the company. And therefore, debt raise, when you're in a situation of financial distress, needs to be carefully thought through by the management of the company, because what you don't want to do is take on additional financing in order to bolster the finances of the company in the short term. But what that essentially does is create a bigger hole for the company in the longer term. So when you're considering your capital raise options, if you're considering external bank debt, it needs to be done for the purpose of growth and for fixing a specific problem and allowing the company to come out of the situation that it is in stronger than when it went into, because that's the purpose of the debt. If the debt is being used to plug a hole and create more difficulty for the company in the longer term, then it may not be the right solution for that company. So it's very important to consider what the purpose of that debt is in terms of taking that on to bolster the company. But when you are structuring that debt, there are a plethora of options available to you. You can, even if you've got existing bank debt, there may be the ability to take on second ranking debt, which sits below your existing debt. There may be the opportunity to increase your existing bank facilities. There may be the opportunity, depending on the nature of your company, to take on trade facilities that allow you to have letters of credit, or essentially deep discount your invoices, or discount your invoices to a financial institution, so that you can recover more cash in the immediate short term to plug a temporary hole in your business. So there are a lot of options that you can have from a debt spectrum to fix problems within your company and take on external debt. But you do need to consider, what is the purpose of that debt, and are we taking on that debt to fix specific problems, to fund future growth, or are we just trying to plug a hole where eventually that hole needs to be repaid if it comes in the form of external debt? And so those are options A, which is to try and raise capital and maintain the company as a going concern. If you can't do that, you find yourself considering option B, which is that you wind down the company on a solvent basis. And what that means essentially is that the company stops trading eventually, and you pay off all the debts of the company. And if there's any money left, that money at the end of it gets shared between the shareholders if there are more than one shareholder. But essentially, you wind down the company and you pay off all the debts of that company. That might mean that the shareholders need to put money into their pocket from their pockets into the company to pay off the existing debts, depending on the level of financial distress. But at least what it does from the shareholders, and why it's an option in addition to injecting equity, is that if you decide that you're going to wind down the company on a solvent basis, you know that once you've wound down the company, that's it. That's the end of the pain for the shareholders if we think that there isn't really a chance of recovery. If you inject the same amount of equity to plug the gap, it may be that in a year, 12, 18 months, whatever it is, the shareholders are asked for more money and they're asked to top up the company again and again and again. And there may be a point where the shareholders reach the conclusion that actually we'd rather just plug the hole that exists at the moment and move on with our lives. So that's why option B exists. Now, what you're all probably thinking is, well, actually, our shareholders might not want to put any more money in, and we might not be able to raise any debt because we've just got a bigger problem. And in that situation, you're in a situation where you need to consider a corporate insolvency process. Now, that corporate insolvency process in the UAE, at least, and this is where we're focusing this presentation, can take place onshore. It can take place in the DIFC. It can take place in the ADGM. And we haven't really specifically distinguished between those jurisdictions for the purposes of this presentation, or indeed the other jurisdictions in the GCC, to create a specific analysis for those jurisdictions. We've tried to treat this in a more general way, albeit with a focus on the UAE, so that we can try and give as many people on this call as much information as possible as to what you might want to do in a situation of financial distress and what your options may be. What we'd like to flag, and we should say this at the start, and we'll probably repeat it over the course of this presentation, is there is no one-size-fits-all solution to financial distress. The do's and the don'ts, the options that you face, will be different for each particular company, depending on, as Hardeep mentioned, the shareholding structure, the underlying financial issue. In fact, the industry that you operate in may have an impact. If you're a financial institution, for example, the role of the central bank in your country will also have an impact, because they will have a view on whether the financial institution would even be allowed to wind down, even if it's on a solvent basis. So there are other concerns that one must consider from other stakeholders before you try and determine what your plan will be. But we're trying to cover off as many items as we can, so we apologize in advance for any brevity in terms of dealing with any situation.
Yeah. So what we've spoken about there is the macro. So what is it that you're trying to solve for? What are certain solutions that may be used to solve for a company which is in financial distress? Now, unpacking all of that would be a many days presentation. Now, within all of this, there are some people that steer the ship, and those people are management. And so that's one of the reasons why we're focusing in on what are the duties of management and what is their role in the context of companies which are in distress. And Ali and I have dealt with many such situations in our careers, and they all ultimately come down to a combination of what the law says and more importantly, how the individuals who take those roles and who are charged with those roles, how they feel on a day-to-day basis as they go through a highly stressful period, which is a company which is going through a difficult financial scenario. So that's the context in which we want to be talking through our slides. Now, what are the concerns of management? They are, what are the duties that they owe to the company? What are the duties that they owe to wider stakeholders? That will change depending on where in the cycle you are, you know, in the distress cycle you are. So, for example, if a company is doing okay, but you know could do better, but not quite in financial distress, such that it's on the edge of insolvency, then a different set of duties apply. As soon as you start veering into a situation where the bankruptcy laws may apply, a different set of duties start applying. So, for example, managers generally and directors generally will owe a duty to the company and to do the best for the shareholders of that company. As you move into a financial distress situation, you have to start looking at other stakeholders. They become important too. So your creditors start becoming extremely important, and what one shouldn't be doing, and we will come on to this later on in the presentation in some do's and don'ts, is start acting to preserve the assets of the company for the benefit of your shareholders only. So your duties start widening during that time. The other thing that we will be talking about in this presentation is what are the penalties and what are the consequences that come out of a breach of those duties. And so let's move on to the next slide, Ali. Thanks. So first of all, who is a manager? So who should? So as in-house counsel, you may be asked by the CEO, you may be asked by the CFO, you may be asked by one of the general managers of a branch or a divisional head. You know, should I be worried? What should I be doing during this period? The company seems to be going through some difficulties. You may be asked by the board or individual board members as to what they should be doing as well. And it's not as clear to say that unless you are a board member, you don't owe any duties to the company. I mean, that we can dismiss. Yes, directors of a company owe specific duties to the company, but UAE law is wide enough, and the company's law and the bankruptcy law are wide enough to cast the net as to who qualifies as a manager owing a duty to the company pretty wide. And ultimately it comes down to this, you know, are you a person authorized to manage the company? So you may be authorized to manage a division. You may be authorized as the CEO. You may be a director. And so all of those persons come into the remit. Do you play an active role in the decision-making process of the company? You are also caught, but under a different law. So what we're talking about here, and we'll come to sources in a sec, is the company's law. We're talking about the bankruptcy law, and there are certain other civil laws as well within the UAE that are covered. Taking a step back from a technical analysis of this, as an in-house counsel and as a lawyer who's advising companies like this, in a distress situation, we should not try and be technical. In a distress situation, we need to be much more sort of all-inclusive and much more prudent in the way we are giving our advice. And so if there is a doubt as to whether a person owes a duty to the company, the answer is probably yes, particularly if they have some form of authority, some form of management. So we go through this list here. You know, that could be a non-executive director, someone who's got duties delegated to them, as I said, sort of divisional type heads and people who work at their behest or through a delegated authority as well. So look at all of those sorts of things and try not to be too narrow in your focus as to who owes duties. can we move on to the next slide, Ali? So with that in mind, first of all, what are the sources that we look at in terms of where these duties come from? There's no clear list in UAE law where you, unlike say, some laws around the world, the English companies law has only relatively recently enumerated sort of a number of lists and listed down a number of duties the directors owe. But we have various sources here in the UAE, and they come from the companies law, they come from the bankruptcy law. Employment law also provides certain duties that individuals owe to their employer. So when we're talking about executive directors or executive management, senior management, they all owe certain duties under employment law as well. The penal code, the civil code, they also impose certain duties on individuals that owe that have a fiduciary type relationship with the company. And what we can't forget, of course, are that there are other regulations that may apply depending on the industry or depending on whether the company is listed or not. So the ESCA rules on corporate governance will apply to listed companies. There is a corporate governance code that applies to banks and banking institutions. And then lastly, of course, whatever the law says, one has to look at the individual contracts of employment or contracts of appointment of the individuals concerned to work out the universe of duties. But saying all of that, what is the main duty under law? And the main duty is really to manage the company to the standard of a diligent person. And what does that mean? Well, first of all, that main duty comes from the commercial companies law in the UAE. It is an objective test. So, you should be acting with prudence. You should be acting, to a reasonable standard that would be expected of a person in your position. Unlike, say, English law, which has a two-tiered test, which is an objective test and a subjective test. So, for example, say it says that you objectively should act like directors are expected to act, with some due care, diligence, and the like. But you should also act to the best of your abilities, in essence. So a subjective and an objective test. We only here in the UAE only have an objective test, and it's difficult to distill some of these duties down because there's no big list, as I've already mentioned. But I've had a go at distilling some of these duties down, and these are: you act diligently, prudently, with skill, care, and in the best interests. You act within the objectives and the powers. You try to ensure that you're not committing any fraudulent acts. You are not misusing your power. And the misusing of power also means any delegated power as well. Authorities matrix, for example, come into force there as well. Try not to make errors of management, errors of judgment. You've got to obviously comply with applicable law and regulations. You do have a duty to avoid conflicts and competing with the company, so making things like secret profits, for example. You owe a duty of confidentiality, so the company is going through financial distress. You need to ensure that you only talk to people on a need-to-know basis, both within the firm, within the company, and outside. And then there are other duties that apply depending on the circumstances. So, for example, entering into certain types of transactions, there will be administrative matters, and obviously the situations where there is financial difficulty and bankruptcy, that there's a whole host of other duties that you have in those scenarios. Next slide, please.
So I think, you know, a lot of this has been covered by what Hardeep has already mentioned in the slide before, but what we tried to do was pull together a couple of simple slides, which are, in order to manage your risk as managers, assuming that you meet the definition of managers for the purposes of the consequences of the bankruptcy code or the Companies Act here, what should you do and what should you avoid doing? So the first slide is what you should do. And I won't read out the slide in all of its glory because there's a lot of information there. And as Rahul mentioned, you know, if you'd like a copy of these slides, please feel free to email us afterwards and we can send them over to you. But I will touch on a few of those that Hardeep didn't cover off on in his first slide or expand on those, which is obviously you must act within your powers. You shouldn't do anything that is outside of your powers. You're expected to exercise judgment, reasonable care, and diligence, as Hardeep mentioned. But in terms of practical steps, how do you show that you're doing that? How do you show that you're acting appropriately? And one key step, particularly as a in-house counsel within a company, is to ensure that there are regular board and shareholder meetings where the financial position of the company is openly and candidly discussed between the stakeholders, being the board, being the directors and the shareholders, essentially making sure that nobody can argue that they weren't aware of the situation. And it comes up a little bit later in this list, but properly document all of those board and shareholder meetings. Take minutes. Ensure that there is a written record of what was discussed at those meetings so that there can be no dispute as to what the decisions made by the company are in terms of how to manage the financial distress. Those decisions may come under scrutiny as part of a bankruptcy proceeding or other form of proceeding. And it's important that those decisions are properly documented so that there can be no dispute as to I said, you said, he said, she said, they said. Whatever that conclusion may be, at least if it's documented, that helps from a management perspective, but also helps to protect your position as in-house counsel in terms of the decision making you are taking. In terms of some of the things that Hardeep touched on in the last slide, often in these situations of financial distress, there may be related party transactions. And what we mean by that is transactions with the shareholders directly, transactions with entities that are owned by the shareholders, which may be able to help this particular company, or you enter into a transaction with that company because they can offer more beneficial pricing or whatever that may be. But it's important when you're in this zone of insolvency or area of financial distress to make sure that those contracts are being executed on an arm's length basis. You don't want to enter into those contracts and then find that actually when you're in the bankruptcy, those contracts are being unwound, fingers are being pointed as to why those contracts were entered into. Less of a legal point, but you know, ignorance is no excuse in these circumstances. But it's important that the board and the shareholders and the management are assessing the company's financial position to identify if they are in the zone of insolvency. Do they meet the cash flow test? Do they meet the balance sheet test? I.e., is there sufficient cash flow to meet the debt that goes out of the company? Are there sufficient assets to meet the liabilities of the company? And if they are not met, then that raises different concerns in terms of whether you should be filing for some form of bankruptcy protection within the UAE, or if they are not yet met but might be, do you start preparing for any form of bankruptcy, and what does that preparation look like? Because being prepared is one of the things that you as an in-house counsel can really help the company with in terms of being proactive and not digging a bigger hole for the company, which they then have to try and find their way out of. We've touched on documenting the board and shareholder meetings, but it's also important to properly document any instructions to act on behalf of the company. In certain circumstances, as in-house counsel, you may be asked by the directors to do A, B, C, or D. And that may be a perfectly reasonable act for you to do in terms of carrying out instruction A, B, C, or D. And depending on your institution, you know, it may be that one of the directors walks down the corridor and says, hey, would you mind doing this? There's no email chain that shows you were asked to do this by the director. Once you get to the zone of insolvency, whereas previously you may have just carried on and done it and said, you know, ABC told me to do it. In the circumstances of the zone of insolvency, it might be appropriate to send yourself an internal note, an email to yourself, for example, that says, so-and-so asked me to do this, therefore I have done it. It documents the request that was given to you for you to carry out your instruction, because as management, assuming that you are not a director of the company as well, albeit you may be a director as well, your duty is to act on the instructions of the company. You are the managers who implement the instructions that are given to you by the directors on the board. Therefore, if you are doing what the board tells you to do, for the most part, and we'll come on to things which you absolutely should not do, you are in a better position if you are following the instructions of the directors. But if those instructions are not documented, you may find yourself in a difficult position where people forget, for want of a better word, that they have asked you to do something. It's also important, I think, to be able to document that you have considered all of the options when making decisions for the company. And that might mean that it's appropriate to take professional advice from lawyers and financial advisors if applicable in your situation. If you've taken external advice, that can help to mitigate problems that might arise without that advice, and can also be used to show that you were taking appropriate steps to protect the interests of the company, which may help to alleviate any potential concerns, which we'll discuss in the coming slides. The other bit that's important to document is any objections to any proposed course of action. There are certain laws within the UAE which actually allow for people who have objected to a certain course of action to no longer be liable for that course of action. So let's say, for the sake of argument, there are 5 directors, it's an equal vote for each director. 4 directors agree on one path, the 5th director completely disagrees. It is important to document that objection from the 5th director, even if the motion will be passed for the activity to be carried out because the 4 people have voted in favor of it and 1 person has not. That may come back to sort of protect that 1 person who objected to that course of action, depending on what the potential penalties that we're talking about in an insolvency situation are. And so it's important when you're documenting the minutes of any meeting to talk about objections to any proposed course of action. I've touched on this briefly, but it's also important for everybody to be aware of the financial position and prospects of the company, to be able to make informed decisions about what is in the best interest of the company. Ignorance is no excuse. You should be talking to the finance team and finding out what the position of the company is. Essentially, entering into negotiations to refinance or restructure a debt facility, for example, but not knowing that actually the urgency of this is that it must be done within the next month, otherwise we run out of money, means that may change the approach that you take in terms of the negotiation stance you take in terms of that refinancing. You may be more willing to accept positions that you might not have done because of the urgency of the situation. But if you weren't aware of the financial position, you might still be trying to negotiate a better position for the company without putting that in the wider commercial context of what does this company need right now. Importantly, in the UAE, there is still a liability that relates to issuing checks. Now, there's been a relaxation of that over time, and I think that that's probably going to be a topic that's covered in some of the other presentations that form part of this series or other series that you attend, and we won't delve into that. But it is important to keep a record of which checks have been issued, when they are going to be cashed, so that you can manage the financial situation of the company. And particularly in the context of a financial distress, just be very careful about writing new checks, because that could come back to create personal issues for the person writing the check. And then the final point in terms of things to do is to ensure open and clear discussions with the stakeholders. There are some points, obviously, that need to remain confidential within the company, as Hardeep highlighted. But at some point, and particularly in a financial distress situation, there needs to be an ongoing, clear and open discussion with the stakeholders. And they may be internal stakeholders, being the shareholders. We need more money, we have to do this, otherwise the company cannot survive. They may be external stakeholders, such as banks or financial institutions. This is the state of our company. This is our plan to fix it. We need XYZ waivers under our finance documents. And it may be customers to say, look, your current terms of payment allow for 180-day payment. In order for us to continue delivering the service that we are delivering, we need to switch that to 90-day payments, 45-day payments, whatever that may be, to allow us to continue to operate. And at some point in the financial distress spectrum, those conversations need to be had in order to allow for people to enter into those conversations. So we've figured out what we should do. And all of those things I should flag are not a complete list of what you should do. That list will be specific to your situation. But in our experience, they've been a list of prudent things that management should do in any event. Doing those things are very unlikely to land you in specific trouble by doing them. but they may not be the full solution to all of the situations that your company faces. And obviously the situation that your company faces will be specific to your company. And as Hardeep mentioned, it may depend on if you are a financial institution, it may depend on whether you are a listed company, or other restrictions or other issues that may face your company specifically. So we shouldn't treat that as a full list of what you should do, but it is a useful list of things that if you are doing that, you will be holding yourself in good stead. So what should you not do? And this is relatively simple. Don't act in a manner which makes you feel uncomfortable. It's probably the biggest point on this slide. As a general rule of thumb, if it doesn't feel right, it probably isn't. And that's the biggest thing that I would ask everyone to take away from this, is to exercise your own diligence and caution. You've all got to the positions that you're in by having gone through years of school, etc., etc. You've built up your own skills and your own skill set of judgment. It's important to use it and to look at these situations and say, I do not feel comfortable doing this. If you do not feel comfortable doing it, record your objection, even if it's something that you are then subsequently asked to do because of management. And even better, persuade management that this is not the right activity if you are concerned about what you are being asked to do. In terms of specifics, don't accept benefits from third parties. That just smells of bribery or some other form of corruption, and there's been too much of that in this region, and none of us frankly need any more of that. As Hardeep mentioned before, act in a manner which competes with the company's activities or creates conflicts of interest. Mislead the board or shareholders as to the position of the company. We see a lot in this region of managers, directors who are scared of telling the shareholders the real position of the company, who are worried that if they disclose the full distressed nature of the company, that will reflect badly upon them. The problem in so doing is that you mislead the board or the shareholders as to where the company is. And that may mean that the board or the shareholders make different decisions to the ones that they would have done were they fully informed. And so it's very important at all times, but particularly in times of financial distress, not to hide what's going on in the company, to be open and clear and to candidly discuss the financial situation of the company. This should go without saying, but don't destroy or alter the books of the company. The books of the company are the records of the company. They set out the financial status of the company. If those are altered or destroyed, it presents, as before, a misleading position of the company. But it also means that if the company does ever end up in bankruptcy, the trustees or whoever is appointed to unravel the mysteries of the company doesn't have the right information to be able to potentially turn the company around and find some form of rescue process for the company. Equally, you shouldn't dispose of the company assets unless for fair market value as part of a transaction. This is not necessarily the time to be fire selling the assets and disposing of them, because that may create issues in and of itself as transactions at a preference or transactions at an undervalue, which would be unwound by the court and cause further problems. And I think one of the biggest points is to act in a manner which impacts the well-being of the management. Don't do something that impacts your health. And one of the things that we will come on to, and I think Hardeep has some words on this as well, we've seen a lot of issues in companies where management are being asked to take on responsibilities. Management go through and live the financial distress of the company. The company is a corporate being, but the corporate being is managed by real human beings. And they have emotions, they have lives outside of the business, they have families, they have other obligations outside of that. And going through financial distress in your company can be a very damaging process for your mental well-being. And one of the focus areas of this entire IHC process is around mental health and mental well-being. And we think that managing the financial distress is a massive cause of stress. And where we've worked on these transactions, one of the values that we've been able to add for management and people going through this is actually to sort of counsel people through the fact that this is a situation of financial distress, but it's a financial distress for the company as long as you individually are acting in a diligent and careful manner. It is not a situation of financial distress specifically for you, and the losses of the company are not your losses unless, as we come on to, you actually created them by bad acts. And it's important to therefore distinguish between the problems of the company and your own mental health. And I'll pass over to Hardeep in case he's got anything to specifically add on that topic as well.
Yeah, I mean, I do not only on that, but also some of the other do's and don'ts. I think what you start finding as a company, as a business starts going through distress, is that information starts drying up. People become less candid as opposed to more candid about problems, about the past, about transactions that may have been entered into, things that should have been said that weren't said, and vice versa. I think one of the things that we say to management, to directors, to in-house counsel is, don't be afraid of asking the hard questions. And that is difficult. It's difficult because when a company is going through the good times, there's often a pattern of behavior that develops where the transaction that is being entered into is the most important thing, and the details are a lot less important because ultimately you don't want to be the person who is standing in the way of the company making money. That starts changing, and the problems with that approach become much more acute when the company is going through difficulties. And we, as say in-house counsel or managers, are at that point not used to asking the right questions and pursuing them. And more importantly, directors and superiors and shareholders are not used to being asked those sorts of questions and responding to them. So don't be put off, and make sure that you counsel your internal stakeholders not to be put off, and don't put things diplomatically, straight, clear, and to the point. So just going on to, well, why are we talking about all of this? Well, in addition to the fact that we are in an environment where we've sort of post certainly the start of the pandemic, we've seen today that there is some distress in China, which may affect the rest of the markets. And we have also seen in the last year or so, actually longer, that there are many companies in this region which are having these types of discussions internally. And so why is this important? It's important because there are real legal liabilities that attach to managers acting in breach of law. And we're talking not only of fines, but we're talking about imprisonment. There are certain things that attach up to 5 years of imprisonment. So you'll see in item A, if you conceal or you destroy or you alter the books of the company, in other words, you're hiding the problems, that is an absolute no-no. Also, it means that you don't have the information to fix the company because it's been destroyed. If you are acknowledging certain debts that are not owed by the company, or withholding documents or explanations with knowledge of the consequences. So, for example, if you acknowledge a debt to a third party which is not owed to them, and that way you are not acting fairly with other creditors, that's a problem. If you lie, you declare false facts. So, for example, if you are openly telling creditors that everything is fine when you know damn well it's not, that's a problem. And so there are real criminal consequences of that. So if we can go on to the next slide. And we continue. So, and I'm not going to read down this list. I think the real takeaway, as I said at the start of this presentation, is not to try and thread a needle. When one's advising on this stuff, we're not trying to be technically correct. What you're trying to do is do the right thing. Does it feel right? Are you acting honestly? Are you acting openly? Are you acting prudently? Are you not burying your head in the sand? All of those sorts of things, the do's and don'ts that Ali went through, are the things that are going to stop a manager and yourselves to breach these duties and for the penalties to flow to you. Ali?
And actually, the penalties and consequences continue, because in addition to fines or imprisonment, there are other consequences that may apply to you, including if you're found guilty of the crimes listed on the slides that we've just run through. The individuals from the management team might be disqualified from being able to act as directors or managers of other companies for a period of up to 5 years from the date of completion of the applicable bankruptcy. And that's a real life issue for many people on this phone call, because if you are engaged in those bad acts, not only does the company that you are representing and providing in-house legal counsel to go through some form of bankruptcy or liquidation procedure, but in addition, your livelihood and your ability to obtain similar positions to the ones that you were previously enjoying are restricted. And so this is a real life consequence that could impact you, and why it's important to stick to the do's and the don'ts and manage your company through the financial distress with honesty and integrity fundamentally. Because if you do that, these consequences do not necessarily flow to you. Disqualification, imprisonment, fines, etc. And the final slide being this slide that talks about if the company's assets don't cover at least 20% of the company's debts, the court can compel some or all of the directors or managers to pay some of the company's debts if they are shown to be responsible for the company's losses. So there are stark financial consequences for managers who have engaged in bad acts, but these stark financial consequences only apply to the managers who have engaged in the bad acts. They are not a consequence of being a manager of a company in financial distress. It is not, as night follows day, I am a manager of a company in financial distress, I will go to jail and I will be fined and I will be disqualified from acting and I might have to pay the debts of the company. It's not as simple as that. It is, those penalties apply to people who have carried out bad acts. And the best piece of advice that we can come out from this presentation is obviously not to engage in those bad acts, not to encourage the other management team, the chief financial officer, whoever else it may be, not to engage in those bad acts, because that is where the real penalties of all of this lie. And that's why the do's and the don'ts of managing yourself through financial distress become far more relevant if your company is going through any form of financial distress. In terms of sort of conclusion, I think it is important to be aware not only of your responsibilities and not only of the applicable laws and what you should and shouldn't be doing, but also the consequences of what happens if you don't follow those requirements. The breaches and the consequences of failure to comply with that are clearly very, very severe in terms of not only financial, but also as to your personal existence as a lawyer. And fundamentally, it's important that each manager should act and make their decisions independently. You do not have to agree with all of the decisions that the company takes. It does not have to be an exercise of committee whereby we all agree on A, B, C, and D as being the courses of action. You are a trained legal professional or an in-house counsel of some sort, and you have got to that position by virtue of being able to exercise your own skill and care and judgment, and you should be encouraged to do so and encourage other people within the institution to do so equally, because many voices will hopefully lead to the right decisions being taken as opposed to one loud voice drowning out all other voices. And it's important that everybody takes their own decisions, because in certain circumstances, people's financial circumstances outside of that business or life circumstances may impact the decisions that they are willing to take versus what the decisions that you are willing to take. And so where your level and where your line is where your level and where your line is. and other people may have different views, and you shouldn't necessarily be swayed by those views. I don't know if you had anything else to add, Hardeep.
I think that's absolutely right, and your line is not what is the legal line. It's actually what is it that you're comfortable with, short of the edge. And I think that's the most important part, because of course each person and each manager and yourselves have families. Oftentimes we are the most of us are expats in this country, and so this is not home in the main part. You know, we want to be able to travel back every summer if we can. All of those sorts of things can be affected if you get this wrong, and the managers get this wrong. And I think all of those sorts of things go into the mix when advising the company, advising management, and yourselves in taking decisions, particularly where if we went to option A, where you've got a distress situation and you're trying to work through the distress situation so that the company is no longer in distress, such as an M&A transaction or an equity raise or a debt raise, the mental well-being, the health of the individuals who are going to be making those decisions are going to be paramount. And so whatever you as in-house counsel can do, and whatever they can do to ensure that every decision they make, they are comfortable with, that means that they don't then make a different calculus, which is that I'm not going to have any part of this. I'm withdrawing my services, so the CEO leaves or a CFO leaves because they're no longer comfortable. That's normally a recipe for the rescue transaction to fail itself, and so there's a real balancing act, and so this being on the right side of the line helps the company ultimately to be rescued.
I think this is the point where we open the floor to questions. I know we've had a couple of comments in the chat, which I'll go through now to see if there are any questions.
Great,
but otherwise,
thank you very much, Ali and Hardeep. Yeah, I invite all the attendees here to ask any questions they might have with Ali, for Ali or Hardeep. You can type in your questions in the Q&A box. I have some questions actually about your presentation, if you don't mind. So first question is, why do you think it's important for management and the company in distress to have separate legal advisors?
I don't mind taking that one. I think that the reality is the interests at certain points in financial distress, the interests of the company may deviate from the interests of the management. What is in the best interest of the company may not actually be the best interest of those particular managers. For the company to go and do X, Y, Z may be fantastic for them, but may have adverse consequences for the managers in terms of their own liabilities or otherwise. For example, let's say you've got an operation in the US. In order for you to go ahead and carry out activities in the US in financial distress, that may lead to Chapter 11 or equivalent proceedings in the US. In the context of Chapter 11, the US is an incredibly litigious society, and there may be numerous lawsuits filed against the company, but also against the directors and against the management. It is absolutely in the best interest of the company not to provide indemnities to the directors and the managers, because that is another outgoing for the company. But it is absolutely in the best interest of the managers and the directors to obtain an indemnity from the company in order to carry out their activities properly without fear of, if there is a lawsuit against me in the US, that is going to personally bankrupt me because I have to pay out of my own pocket to protect my name and to fight and to get rid of that suit. However vexatious and however ridiculous that suit may be, legal costs in the US are astronomical, and that impacts you financially as a director or management. And there are certain points in any given transaction, particularly when there's financial distress, where the interests of the company or the managers may differ from each other, and it's important for the managers to have their own legal counsel to advise them in their own individual capacities, including as to, and I know Jonathan's going to come on next to talk about employment issues. As to employment issues, you may decide that actually I don't want to be part of this company anymore. How do I navigate my employment contract? What does it mean if I hand in my notice, but I've got a 6-month notice period? Am I actually going to be outside of the tent, but also still part of the process for those remaining 6 months? How do I navigate that process? And without separate legal counsel, if you only have one set of lawyers that represents the company as a whole, those lawyers owe their duty to the company. They don't owe their duty to the directors that they speak to or the managers that they speak to. And that's why I think in a situation of financial distress, there can be a value to engaging a law firm for the company, but also a law firm for the managers and directors in their own individual capacities.
Great, thank you very much for that answer. Ali and Hardeep, you might have seen a couple of questions come in from the audience. Do you mind taking them up? We still have about 5 minutes.
Sure. I mean, I think both of these questions relate, and I'll let people know what the question is. It's the definition of manager seems to be broad and unclear. Is there a source, e.g. legislation, where we can find a clear definition? And how can an in-house counsel be construed as a manager of the company unless they are listed as a manager as per the trade license? And the answer to both of those questions is that the definition of manager is almost intentionally not particularly clear, because it is a nebulous concept. It is the people who engage in the decision making of the company. There are definitions of managers that you can find throughout the legislation, and we will send to the person who asked the question, we will send, we can send a summary of where the legislation can be found that you can run through. But I think the reality is that it doesn't relate to just the managers on the trade license, because if it just related to the managers on the trade license, everyone would be queuing up to say, don't put my name down on the trade license. It is the people who are actively making the decisions and determining the answers to what's going on who constitute managers. Because if you were to simply digest it into the people named as directors or the people named as the manager on the trade license, the actual decision makers could hide behind puppets and get away with whatever they want to get away with without actually having to engage with the relevant legislation. And that's why the definition of managers does not necessarily lead to a specific group of people where it has to be these particular named individuals or these particular positions within a company, because each individual company is a different institution, and the power and the decision-making authority and the decision-making matrix will be different for that company. And that's why it's not clear that ABC is definitely a manager and XYZ is definitely not a manager.
Great, thank you very much. And we just have 1 minute. If you could I could throw one question at you. How are the corporates coping since the start of the pandemic? Are you finding that you're receiving more inquiries from companies in financial distress?
Yeah, look, we are. But one of the quirks of this particular region is that companies never phone us up saying that we're in financial distress. They just have certain problems with a particular facility, or they're in breach of there's a trigger in a facility, for example, and oftentimes the legal kind of question is quite narrow, and you start peeling back the layers and you start realizing that actually if you breach that facility, there's cross defaults, and then you look behind what the issues are, and then you realize that actually the business model itself needs to be looked at and fixed, and so they often come from a different angle when they get to us, and oftentimes I'm sure that they will get to in-house counsel from very obtuse or very specific questions that are being asked of them, as opposed to the wider picture. And I go back to one of the things that I said in the presentation, is that don't be afraid to ask questions. You're not being rude.
Great. Thank you very much, Ali and Hardeep. Really great presentation, very insightful. If anyone would like a copy of their slides today, or if you have a question generally around the topic, then please get in touch with Ali and Hardeep directly. Share their email IDs and their phone numbers in the chat box already. I know I think there's another question that's come up, but unfortunately we don't have time. I'd ask the person sending the question to get in touch with Ali and Hardeep directly. Well, again, thank you very much, and we'll see you hopefully soon in person, but now we have to go on to our next presentation. Thank you very much, and I'll ask you to close your webcams.
Thank you. Thanks, everyone.
Hi, Jonathan. Good to see you. You're on mute. Okay, so our next presentation, you've already seen Jonathan on your screen. This presentation is about the UAE trends in employment law. I'd like to introduce Jonathan. Jonathan advises numerous multinational companies and regional powerhouses on international transactions, company formation, agency and distribution, joint ventures, and corporate governance in the UAE, GCC, and the broader MENA region. And it's very interesting to me, but Jonathan is a fluent Arabic speaker, and he frequently manages complex, contentious matters in the region, including arbitrations, local litigation, internal investigations, compliance reviews, and executive level employment. So thank you very much, Jonathan, for taking out the time and presenting on this topic. If you would like to share your screen and take it forward, that would be great.
Thank you very much, Rahul, and thank you to Hardeep and Ali for the very interesting presentation. Thank you especially to Ali for the lead-in to this discussion on employment today. That was very kind of him. Thank you. And I'm just sharing my presentation now. I'm a lawyer, not an IT person, so if I mess this up, please excuse me. We're doing our best here. Is that working, Rahul and everyone else?
Yes, I can see it very clearly. Yes, please go ahead.
Wonderful. Thank you so much. Thank you, everyone. Before I start today and get into the presentation, I want to say that employment law in the UAE is fairly straightforward, and it's an area that is a core competence for most in-house counsel. Having said that, it's an area where an ounce of prevention is worth a pound of cure, and having external counsel get involved at various stages in the employment life cycle is very important and can be very valuable. And I'll just say from the outset, I think places where external counsel like us can be helpful are at the pre-onboarding stage, when you're going to bring somebody on at the executive level. You want to make sure that you put in safeguards for the company. Exits, of course, and we'll discuss that today. Investigations, when certain issues arise, whether that's violations of sanctions regimes, other kinds of internal investigations, and then more generally policies. Coming to a firm like ours to make sure that you have really good, strong policies in place, an employee handbook, etc. These are the kinds of things that I think external counsel will be well served to retain external counsel for these sorts of things. Just briefly about the firm, we were established in 1999. We have 9 offices around the region. We're an international firm, but built for the region with a strong regional focus. Our lawyers speak all the languages of the region, and we assist mainly multinationals, but also regional companies with work in North Africa, the Levant, as well as the Gulf. So I'm going to give a brief overview of what's new. And as you know, in the UAE, there's always a lot of chatter about things that are coming, new regulations, new legislation. How these things actually come to fruition is another story altogether. Before that, Rahul, we're going to ask folks I should just say, we'd like to be interactive today. I love to hear myself talk, but I also would much prefer to interact with the folks on this call today. So we're going to have poll questions, and we're also going to have a Q&A. Please feel free to stop me and ask questions in the presentation. Don't be shy. So Rahul, if you could please pop up our poll questions now, that would be great. So first, have you had a labor and employment issue in the UAE in the past 12 months? Has it in the UAE and in the GCC? Yes or no? And then if anybody wants to say, they don't have to, but in the chat room, what have been the major issues that you face or are currently facing? Give a few more seconds and then close. Rahul, should we, are the results of the poll in?
Yeah, just 10 seconds more. I see people are still replying.
Lovely. So I think this confirms what we all think, which is that this is a bread and butter issue that falls across General Counsel's desks on a regular basis here in the UAE. As a regional hub, it looks like less of you have had GCC-wide issues, but at least close to 1 in 4, 1 in 3 have had some kind of regional issue this year. We'll talk about regional things briefly while we go ahead. So in the UAE, let's just move quickly to what's new. And what's new largely is a result of COVID. Coronavirus has led to significant changes in the relationship. These have phased out as I think work life has gotten back to normal in the UAE more quickly than in other jurisdictions. But this was all as a result of Ministerial Resolution number 279 of 2020. And the goal was to help companies and their employees come to grips with the pandemic. So what did this allow? It allowed companies to put in work from home. This is one of the things that's happened. Now, again, as we discussed, there is a return to office, and so employees can resist this return to office if they'd like, but again, they have to have a valid medical reason. And so increasingly, we're seeing companies here return to full employment back in the office. Paid leave. This was employers were allowed to specify dates that employees had to take annual leave. It confirms that this can be approved unilaterally, but it calls for some kind of agreement. And the resolution actually was a little bit disappointing, I think, for employers in that it sort of half mandated things, but then ultimately said, no, you need to have approval from your employees. It allowed onshore employers to mutually agree periods of unpaid leave. And it also allowed for parties to mutually agree to a reduction in salary, as well as a permanent reduction in salary. Again, those had to be by consent. I think we heard of numerous and participated with our clients in numerous temporary reductions, unpaid leaves, et cetera. From our experience in the market, most companies are back to full payment, are not furloughing employees any longer. And so a lot of these things that came in place in the last year have sort of just the nature of business has made them not obsolete, but less relevant. Redundancies, again, less relevant than they were. I'm going to go now to something that just came out. It's a little bit more recent, and this is projects of the 50 emeritization. Now, these are announcements. They have not gone into place, but these are things that I think we all look at on the horizon. They've been discussed if you've been in the region, if you've been in the UAE for a long time. So there's a push on emeritization, and particularly on moving Emiratis into the private sphere. Among this is apprentice programs, so train to hire, vocational training programs for Emiratis in private and semi-governmental organizations. And supposedly there will be financial incentives linked to hiring Emiratis. There also, we understand, will be recruitment targets. Other countries that you may be familiar with, Saudi being the main example, already have these in place. But private sector companies in the UAE are supposed to ensure that they have 10% of the workforce Emirati. And again, this should be graduated, 2% each year. There is some budget that the government is looking to put into this and to help subsidize private sector companies. Again, I think, how much of this comes to fruition is another story. And then unemployment benefits, again, will be extended to Emiratis who are in the private sector. Now, another new development are all of the remote work and different visa schemes that have been into place in the last year. And I think, these have all come into place with the goal of making the UAE an attractive and competitive place to do business in a post-COVID world, and also to take advantage of some of the remote work opportunities that COVID brought about. So this remote work visa is particularly designed to attract folks from elsewhere to the UAE. Basically, it's a one-year visa, self-sponsorship. It's about $300 a person, plus processing medical insurance. You have to show that you have a valid source of income from an employer or from a business outside of the UAE. Once you get this, you can obtain services, do utilities, medical, schooling, housing, etc. So this is designed to attract employees either who can work from anywhere or business owners to the UAE. Other visa schemes, are the Golden Visa. This has been around, I think it predates COVID, but basically this is a long-term residency visa for highly qualified investors, white-collar professionals, those who have made major contributions to the UAE. It's a 5 to 10-year visa, and this is I think designed to put Dubai or the UAE in general on a track with places like Singapore and other sort of regional hubs around the world that have more attractive long-term residency policies in place. The other recent visa is the Green Visa, which basically bifurcates residency from employment. As we'll get into in our presentation here, generally residency is linked to an employment relationship of some kind. But this is for skilled employees, skilled workers, investors, business people. It basically is a 5-year visa that allows you to remain in the country, and you can sponsor parents, children. It also gives you a longer period to renew documents. And I think the main benefit here is, again, not linked to employment. So it gives you a right to remain here without having an employment relationship with a legal entity, a company. Finally, we have a freelance visa, which has been announced at the federal level. We don't have a lot of information on this yet, but we assume it's going to be similar to freelance visas, which are available in free zones, and basically lets people have a visa that permits them to provide services, professional services, media, etc., marketing, to a number of clients without having an employment relationship. So, it's supposed to encourage small and medium-sized enterprises, solopreneurs, these kinds of things. We have a scenario here, which probably will be easy for all of you, and is a little bit irrelevant post-COVID, but we'll discuss it nonetheless. Ellen's employers advised that her salary is going to be reduced by 25% for 3 months. She consented to the reduction, and she signed an addendum to her employment contract. After 3 months, it was further reduced without warning. Her employer didn't seek her consent or apply to the ministry. She's not aware of her options. She's receiving a further reduction for a period of 6 months. In the Q&A, or does anyone want to point out various issues with this? I'm happy to answer, but I'd love to hear your thoughts. All right, I see that you're all shy. I'll just say, look, the main issue here is that these provisions that were put into place had to be with consent. Ellen here The second reduction and the third didn't have consent. There wasn't notice to the ministry. These provisions were put into place to protect employees. And so as an employer, as an in-house counsel, whenever you're negotiating in a post-COVID world, reduction, whether temporary or permanent, the rule of thumb is that you need to get consent, you need to get it in writing, and you need to amend whatever documentation you submitted either to the Ministry of Human Resources or to the Free Zone to properly reflect those consensual changes to the employment relationship. We're going to move on to a GCC focus just briefly. And I know this is UAE, but so many of us deal with cross-border issues in the GCC, and so we wanted to give a little bit of attention to this today. Rahul, can you put up our poll question so that we can get responses to this before we move forward, please?
Yeah. Coming right up.
So have you dealt with a cross-border secondment in the GCC? And then how do you manage this? Any thoughts on how to manage this? If you want to put into the Q&A, the question box, that would be great.
Right, I'm going to end the poll and show the results on the screen. And we're also getting answers in the chat box, Jonathan.
All right, so about 1 in 5 of you have a cross-border issue. Wonderful. So this will be relevant to 1 in 5 of you and interesting, hopefully, to the remainder of you. So just as an overview, and I'm happy to share this with you, countries in the GCC generally have similar or comparable labor law systems. If you look here, probation is generally 6 months or between 3 and 6 months in a few cases. Working hours are about 48 hours, 44 to 48 hours a week. They all have overtime provisions, similar vacation provisions, similar gratuity provisions, and similar notice period provisions. So it's not fair to say that your UAE knowledge carries over one-to-one, but there is continuity in terms of labor law across the Gulf. Rajesh, thank you. We will for those who reach out to us, we're happy to share this chart and other elements of the presentation. So what are some of the major labor issues that are unique to the GCC? It's a multicultural market, and so you have folks from many different legal, cultural, economic environments who are all here and all coming from a different point of view. This leads to lots of different problems: sharing of information, what people deem to be confidential, what they don't deem to be confidential, issues of embezzlement, collusion, corporate morals, what may be a no-no in one place is not in another, and also issues of what's deemed to be harassment, sexual harassment, power harassment. The laws are frankly don't address these areas in great detail. So that's another issue. Well, again, embezzlement, these kinds of things could require an internal investigation. So we have a question: Is this the same for all nationalities? And the issue is, if you're in the private sector to the labor law, i.e., not in the governmental service, then yes, this would apply to any person in the working across in the private sector. So what are ideal strategies for dealing with these kinds of issues in the GCC, but anywhere? Training and evaluation of employees, putting good handbooks and resources into place, communication, and having fair and open procurement procedures and audits. Thank you, Rahul. So often folks in the region, folks in Dubai or the UAE will, will hire independent contractors in other jurisdictions, whether that's the GCC or elsewhere. So you hire a business development person in Egypt or Saudi, etc. This is a key issue. If they are hired as an employee in the UAE and they have a UAE employment contract with your company, they will be subject to UAE labor law, and they will be able to seek end of service benefits, all of the statutory benefits that you enjoy in the UAE through UAE courts. Now, maybe in practice that somebody in Pakistan is not going to do that, but this is a risk that we always recommend that employers here avoid. So if possible, when you're hiring people in these jurisdictions, either do so through a local subsidiary, a local manpower provider, or if local law permits, an independent contractor. But the key point here for you is, if possible, do not put these folks on an employment contract here with a residency visa, et cetera, so that they are entitled to benefits, statutory benefits, and contractual benefits under UAE law. How can we access the recording at a later stage? Rahul, I think, will we be sharing this with folks outside of after this presentation? We will, correct?
We will have the whole video of today's presentation available on our YouTube channel later on. But I do insist, if you are here, please, the presentation is here, and you can always get in touch with Jonathan later on by email. He'll be happy to share.
Yep. We're happy to share this with you and to answer questions or general questions after this presentation. So we talked a little about independent contractors, things to avoid there. The other issue is secondment agreements. When you have an employee here who you want to send out to work in a place like Saudi Arabia or Kuwait, and this frequently happens, where a distributor will say, hey, we want a business development person, or we want a maintenance and repair person to come out and to sit in our shop. These are very common. The thing that the issue is that they often give rise to dual liability for both the employer and the distributor or the person who they're being seconded to. So the ordinary relationship, as we see here on the left, is that the employer has a secondment agreement, they send the employee out and they continue the employment relationship. Now, that doesn't work in the GCC. Why? Because the place of secondment, the distributor, et cetera, has to then issue a residency permit and enter into an employment relationship with that employee. So what we frequently recommend be done is that the employment relationship with your employee either be terminated, which is ideal, or if not possible, paused or suspended with clear contractual language in place that has a clawback if they do try to request benefits in multiple jurisdictions. Then a service agreement in place with your distributor in another jurisdiction where you pay salary and benefits and they maintain an employment relationship with this employee. Once the secondment is over, they come back and they pick up again. It may not always be ideal or easy to sever that employment relationship, but there should be some paperwork in place that clearly spells out that the employee cannot, quote unquote, double dip, receive benefits in both locales. And we often see that this occurs. I would say the risk is not often realized, i.e. that a person files suit in Saudi Arabia and the UAE, but there may be claims that arise and can cause real headaches in multiple jurisdictions. Can an employee work for a subsidiary with a parent company visa? Well, I guess the question would be where. Generally, this is with Rastwana. Generally, in Dubai and the UAE, if there is a common owner, common shareholder, this can be done. It's always better, of course, to have the employee be under the employer. That's because there are SNAP inspections and reviews of employees on site. But it's generally understood, and particularly if you have a national service agent, you share a national service agent if it's a branch. These kinds of arrangements may be permitted. Okay, I'm going to move on. Any questions about GCC? I know that's a little bit very, very general, but the idea here is that if you're sitting working for a multinational in the UAE, the two things you really need to make sure of is when you have independent contractors or folks in other jurisdictions, they aren't able to form some kind of employment relationship that would entitle them to benefits here. And if you're sending folks out into other markets, that you make clear who is responsible for what contractually and try to prohibit double dipping or confusion about whether you or your distributor or partner in that other jurisdiction are liable. We're not going to have a poll now. I'm going to go right into UAE labor law. If there are any questions about GCC that you'd like to ask, maybe now would be a good time to raise them. I'll wait a few seconds and then move on to our overview of UAE labor law. All right. So this is why you all came today. Oh, we do have a. Within Dubai, how are secondment agreements possible? What are the provisions to be included? Thank you, Kartika. That also is a very broad question. What kind of secondment are we talking about? From a free zone to an onshore distributor? Look, generally, and I'm going to get to this in the UAE labor law presentation, generally these secondments are going to be require, if you're onshore, you can get a temporary work permit and go ahead and work, be seconded to a partner company in the free zone. Moving onshore from a free zone company is more difficult, but not impossible. But it is a very location to location specific inquiry because we have 40 free zones. Temporary work permit. Who will be held liable for labor? So we have another question here. In case of a secondment by way of temporary work permit, who will be held liable for labor dues? So if we're talking in the GCC, somebody is entering into a new labor relationship in another jurisdiction, then and you've cut off or suspended or terminated your employment here, then the distributor or whoever it is that you're working that's holding that employment relationship in the other jurisdiction will be responsible. Here, if it's a temporary work permit, you've gotten approval for your staff to work in DAFSA or JAFSA, that's not an employment relationship. The employment would continue with the employer of record, and you would be held liable for labor dues, etc. Is there a way to determine which company owns the work product of the seconded employee? Thank you, Miriam. I think this is something if there were issues with intellectual property, and I assume that this is what you're referring to, you would need to spell this out both in the employment contract, so that you would have ownership of that intellectual property, it would be assigned to you, and that the employee would undertake any acts necessary to assign that IP. You would also then need to have an agreement in place, and preferably in your service agreement with your distributor or this party that you're seconding this employee to, that any intellectual property that the employee develops while they're with that entity would also belong to you. And those would be contractual arrangements that you would put into place both with your counterparty in the other jurisdiction and with your employee. So I would say I would not leave that to mandatory provisions of law. I would make sure that we have clearly drafted provisions in our contracts that cover that. Thank you, Miriam. So I'm going to get right into it. UAE labor law, 1980 was when it was promulgated. It's one of the oldest laws in the UAE. It applies across all the Emirates and free zones in principle. It has carve-outs, so government employees, the military, domestic workers, these folks are excluded. Onshore, we've talked about this a little bit already, the Ministry of Human Resources and Emiratization, or MOHRE, is the main regulator. And each free zone, the Free Zone Authority has its own labor regulator. And so there are different regulations, different employment contracts from free zone to free zone. JAFSA and DAFSA here in the UAE, here in Dubai, pardon me. I would say also DDA, the Dubai Development Authority, have the most robust labor regimes of the various free zones. DIFC and ADGM, which we're going to touch on very briefly if we have time, perhaps not. They have independent employment law systems that are common law based and that are very different from what you see onshore and in the other free zones. Labor law is generally employee friendly. The following issues require careful attention for employers: overtime, vacation, and I think labor contract termination. We have here very briefly, there was an anti-discrimination law that was put into place in 2015. It focuses on stopping religious extremism and discrimination. There is not a comprehensive harassment law. or other kinds of modern statute on these sorts of things. Labor law has been amended multiple times, and a new one has been discussed. We don't have one yet. So how do labor contracts work in the UAE? There's a standard form labor contract with the Ministry of Human Resources or the various free zones. Sets out basic terms, remuneration, commencement date, term, etc. Now, an employer, sometimes there is an offer letter or a contract that's provided prior to this. There also may be a supplementary agreement that's put into place that has terms on things like confidentiality, bonus provisions, participation in stock plans, etc. that are more complex and outside of the bounds of a standard template form labor agreement that we have here in the UAE. Work rules, some companies have them. We recommend that all companies have an employee handbook. If you don't, please get in touch with us afterwards. We're happy to help you draft one. These should cover rules for employees internally. Again, the goal should be to set rules where there are no provisions of law, confirm and give additional insight into areas of law where there's a little bit of gray. So I would say, for example, suspension and disciplinary penalties are in the law. They're not terribly clear, and so it's really good to have provisions on that. It also sets out management rules for the multicultural workplace here in the GCC. I'm going to go quickly over these things. I think most of you know these, but this is an overview. So, let's just talk about basic rights, basic provisions under the labor law. So after a year of continuous employment, 30 calendar days of annual leave, that can be divided up into 2 different tranches by an employer. It really depends on the kind of employment that's going on. This is a major requirement. Gratuity, it's basic salary paid through the WPS system, and that's again after a year of continuous service. We're going to get into a breakdown of that a little bit later. We have another question. Should the employee manual be attested by the Ministry of Labor? Thank you, Darian. Yes, the law requires, or the statute does state that. Also, things that you post in the workplace should be confirmed by the ministry. In practice, we see that this doesn't really occur. But ideally, yes, and I think we would encourage folks to at least file these with the ministry if possible, or the relevant free zone, so that they can say that they've complied. Working hours and overtime, so it's 48 hours a week. This can be extended up to 9 hours a day for employees in commercial establishments, hotels, and restaurants, watchmen. Termination, unless a different period is stipulated by contract, it's a minimum notice of 30 days. Now there was a ministerial resolution that went into place several years ago. Notice period should not exceed 3 months. And there is a compensation in lieu of notice for either party if the terminating party fails to follow the notice period. So that's the full amount if you're the employer, if you fail to follow it, and it's half if you are the employee. Is the employee handbook a mandatory provision? No, Kartika, it's not a mandatory provision. It is something that we find is a lifesaver when there is an employment dispute that progresses to court, because you're able to state that if an employee makes certain claims, and those are covered in the employment handbook. So, for example, bonus. An employment handbook can say that across the organization, an employee is only entitled to bonus if they're employed by the company in December of the year in which the bonus is accrued. Well, this is a very nice provision to have if you have an employee who's claiming bonus when they were terminated halfway through the year, because it makes clear that there was an internal arrangement between all of the employees and the employer about when bonus is accrued and when it becomes due. So it's not a mandatory provision, but I would say sophisticated organizations have these in place, and they often save significant amounts of money because they're good pieces of evidence to have when a dispute progresses. I'm getting a little bit short on time, so I'm going to move beyond this. But we have, basic things here. Emeritization we discussed. There is Tauteen. That I think the main thing to point out here is Tauteen. You need to now run all of your new job postings through Tauteen before you go ahead and hire an expat. I think this is going to become an increasing issue based on what we've seen, the 50 plan, et cetera. And we should see more active MOHRE introduce new emeritization requirements, or maybe not new, but more oversight over emeritization requirements. So it may not be sufficient anymore to post in Tauteen and then not actively interview. It may be that you actually really need to make a good faith effort before you can hire expats. We have an anonymous attendee who's asked us, can an employer refuse access to the office to non-vaccinated employees? And I feel like this is maybe a ringer. We actually were asked to submit a couple of questions, and my associate and marketing manager, who I have to thank both of them, Taskeen and Chrissy, for putting together a great proposal, great presentation today. They both raised this. So I think the answer here is we need to tread carefully. But if there is a compelling reason to refuse an employee access, and public health is one of those things, then you can certainly ask somebody to stay from home. So can you mandate? There is not a clear provision in place on this, but there may be public health arguments to make to refuse someone access. We have another question here. Disciplinary termination not qualifying for termination under Article 120. Is the employer expected to provide several warnings before termination, or can termination be done with 30 days notice? So we'll get to this hopefully a little bit later, but I will just answer this in the least lawyerly way possible. If you terminate for convenience and you have a 30-day notice period and you follow that, then no, there's not a reason to give warnings. Warnings can be helpful because there's this issue of arbitrary dismissal, which we're all, I'm sure, aware of. Arbitrary, the Articles 122 and 123 of the law states that if you terminate an employee for an unjustified, without a business reason, without a valid business reason to do so, that person can be entitled to up to 3 months of compensation salary as determined by the relevant judge, right? So if you don't provide warnings, if you don't provide a justification, put it in the file for performance, and you document it, there is a risk, and we all know, every employee here knows this, they will all claim arbitrary dismissal. There's a risk that an arbitrary dismissal claim is seen as valid by the courts, and the judge provides between 1 and 3 months of termination compensation to the employee. Thank you, Amjad. Any plans for a mandatory social security system for the private sector? No, not that I know of. This is, in my opinion, a no-brainer because we have all the time companies that don't properly accrue, and then you have poor employees who don't ever see end of service benefits. It would also be, as we all know, a fantastic way for governments in the UAE to have revenue to invest, ostensibly in their own projects. So I don't know why we don't have this, but this has been talked about for years, but nothing concrete. But it would be great to have a mandatory social security system where companies pay on a monthly basis, and the government then backstops payments out to employees when they're terminated. I think we got to this, Rajesh, the question about arbitrary dismissal. I'm happy to have a conversation on that offline or via email. Is emeritization affecting the free zone companies? Thanks, Marilyn. Yeah, that's a good question. I think it's too soon to say. These announcements of 10%, et cetera, are brand new. I think the free zones have always been a carve out in terms of onshore regulation. So I would say less so. But the goal is to increase private sector participation, Emiratis in the private sector. The reason we want to do that is because obviously government employment is a kind of subsidy. The government here has a far-reaching vision. They want to have their citizens be involved in cutting-edge work and be able to build and grow profitable businesses, sustainable businesses here. So I think it's too soon to know, but something to look out for. I would imagine that free zones are going to be a place where this is less important than onshore. PROs, I think we all know about PROs. I don't want to get into great detail, but these are the kinds of folks that make government submissions, visas, cancel. A couple of important things here. You don't have to employ a PRO unless you have a certain level of a number of employees, or unless you're engaged in certain sectors, you can use an outside contractor. If you're in one of those, if you have a threshold level of employees, it's rather high, or you're in certain sectors, you do need to have an Emirati. But you do need to employ your own PRO, but that's pretty rare. Working hours and overtime, we discussed this. I can get into it in more detail if you guys would like me to, but I'm going to skip it in the interest of time. Paid vacation, again, we discussed this 30 days per year, and it can be divided up to 2 times. One thing here that I do want to talk about, and I think is really important, we see folks who gather together paid vacation over a 2-year period, and then when the employer goes to terminate the employment, there's basically 2 months of compensation that's owed. So 2 things to point out here that I think are really key for employers, for in-house counsel. One, and this is another area where I think the handbook is important. One, use it or lose it provisions in contracts and in the handbook. That is, the year that you accrue it, you must use all of it or close to all of it, and you can only roll over a certain amount. I think that's a lifesaver for a lot of companies. It saves a lot of money at the end of an employment relationship, and it should be in any sophisticated company's handbook or employment contract. The other thing here that's really key to point out is you cannot force an employee to take vacation during the notice period. You can try, but this is something that's not going to be looked at kindly by the ministry or the courts. Once you issue a termination notice, that basically freezes annual leave unless it's already been agreed upon and documented. And so, again, use it or lose it is a really good thing to make sure that you put in. Inspection in place of employment. I have a question here. Can you implement a use it or lose it policy for leave days in the UAE and only allow carry forward each year of a set number of days, and all other leave days are forfeited? Thank you, Tinas, for the question. You're right above us. It's nice to see you again. Yes, you can implement a use it or lose it policy and allow a carry forward. Basically, the principle behind this is that an employer can set the leave date and require the employee to take leave. So it should be clear in the handbook or among your HR professionals in your team. They need to instruct their employees that they must take leave. If they do not take it, they can only carry through a certain amount. And what if the employer rejects the leave? You have a right as an employer in the UAE under the labor law to place them on leave. They only work if you need them or require them to. So I think you can unilaterally impose leave, paid leave, I should say, not unpaid leave. So yes. Does hiring a GCC national, not an Emirati, count as a percentage of localization? So we don't have the same thresholds as we do in Saudi. It's not as important of an issue yet. I would imagine here, no, it's going to be Emiratis. I may be wrong, but again, the goal here is that of the 1 million+ Emiratis here, the government wants as many of them as possible gainfully employed in the private sector. So, hiring a Bahraini is not necessarily going to help with that. Thank you for the question. Inspections. Look, it's just important to know that the Ministry of Human Resources and the free zones are out there. They do make inspections. They come to our offices. They come to your offices. They will fine folks if they find people who aren't supposed to be there. Key point here is temporary work passes. If you got folks working onshore who need to go to the free zone, you need to make sure that your counterparty there, whether it's a client or a sister company, has a temporary workplace for them, and put that into place. It's important. I have to say that I haven't seen a ton of fines, but it happens. Rahul is telling me that I've got 15 minutes left, and I want to get to the meat of this. So I'm gonna move through workplace management, terminating labor contracts, labor courts, these sorts of things. We're happy to share this with you, and we're happy to do that. It's not a problem at all. I'm going to move now to the meat of I guess this is all the meat, but to what I was thinking of as the meat of this presentation today, which is non-competes and confidentiality and employment terminations. And these are places where I really think that external counsel is so important because we deal with these. We have a range of experience. We know what's going on in the court. There isn't a principle of stare decisis of binding precedent with courts here, but we know, and for example, we've seen in the past year that quality of decisions, in our opinion, has decreased reasoning, and they've been more employee friendly. So we see trends. Granted, they're anecdotal, but it's something that as an in-house counsel you may not have exposure to in the same numbers that we do. So the first thing is confidentiality and non-compete. Why is this so important? Look, we're in a data-driven world. This is a key for businesses nowadays. Competitors battle for the same pool of clients. Relationships are key to success. Proprietary information is priceless. It's how we battle and win in the 21st century. So who should be subject to your post-termination, non-compete, and confidentiality obligations? Your executive level staff, C-level staff, key sales and business development staff, your key technical staff, and staff with knowledge and access to sensitive information and key clients. You don't need to put in extensive confidentiality and non-compete obligations for low-level staff or employees. Even I would say, you know, a junior business development person, unless they really have key relationships, that's somebody that you want to be a little bit, have a little bit of a different approach to. So non-competition generally. Labor law permits non-competes. You have to meet these 5 requirements for them to be enforceable. The employee has to be over 21. The restriction needs to be limited in time, needs to be limited in geographic place and scope, and it needs to be for the legitimate interest of the employer. Courts are unlikely to redraft an unenforceable clause to make it enforceable. You've got to get it right when you draft it and have them sign it. They can be drafted broadly, and they can include any of these elements: joining a competitor, starting your own competitive business, approaching clients and contacts, poaching employees, i.e. non-solicit. And I'm going to get to this. Look, these are important. They're very difficult to enforce in the courts in the UAE. The more narrowly tailored they are, the more that you mention a specific competitor or group of competitors, the more likely you are to be successful. Even with that, we've had incidents within a free zone where employees have moved from one competitor to another, and that competitor was mentioned in a non-competition provision. The free zone still didn't take effective action. So while this is key, it still is very difficult to enforce. Look, confidentiality is governed by the labor law, the civil code, and the commercial companies law. Employees need to know that they need to keep industrial and trade secrets confidential, and there are provisions to enforce this. It can also be through criminal complaints, the penal code. And if it almost certainly now will be through the internet. The cybercrimes law is going to enhance punishments. And so this is something where you really potentially do have teeth. If you have a person who is downloading client lists, confidential information, data, etc., this is something where you might want to strongly consider filing a criminal complaint and using the penal code and the cybercrimes law as a way to try to stop this kind of behavior. As I said earlier, enforcement is challenging. The ministry, free zones, they can block visas. They don't do it. They think it's a private dispute, and they really don't like to get engaged. UAE courts take a long time to run decisions. The key thing for in-house counsel here to know, there is not injunctive relief. And so it's not like in the States or in common law jurisdictions where you can go on a Monday morning and slap a TRO in place and enjoin somebody from going somewhere. No. Again, one aggressive option, and we counsel clients on this a fair amount, work with colleagues, a criminal complaint. It's not pretty, it's not something that I would prefer to do, but it seems to be one of the only effective tools here if there really is a serious breach of confidentiality or of competition. No quick fix. So again, as I said at the beginning, ounce of prevention is worth a pound of cure. One of the things that we're gonna discuss is making sure that they are properly tailored. So our keys here: duration, 6 to 12 months, location, UAE only, even better, Emirates specific, Dubai, Abu Dhabi. Name the sector, name specific competitors, name specific product lines. Because you don't have injunctive relief, you might want to consider liquidated damages. This would at least give you a claim in a civil suit to recover, quantify the harm and to recover some of the loss. Now, again, consider having key employees sign an NDA with a choice of law provision in a jurisdiction that allows injunctive relief. That may be NFC or England. That may be an effective approach. Again, the stronger the clause, the less likely you're going to have issues with enforcement. I'm going to skip over this, but we're limited on time. Your IT system is critical. It's really important that you work with IT professionals in your team to discuss ways to monitor the movement of unauthorized movement of data, and to make sure that you have some IT provisions in place that makes the likelihood of theft that's not detected very low. I'm going to skip over our non-compete scenario. I think, Rahul, we have a limited time, so I'm just going to go to managing employee exits. This is something that's really important for us and for folks to know about. So UAE law makes it relatively easy for employers to terminate. You can terminate during probation period without a cause and with basically, without a justification, without cost to you. You can terminate for cause in limited cases, and it's mainly Article 120. That's basically it. We haven't gotten into that because we haven't had time, but there are very limited cases in which you can terminate for cause. You can terminate without cause, and we discussed this issue of arbitrary dismissal. Again, for unlimited term, 30 days notice minimum, up to 90. For a fixed term, and this is a place like JAFSA, you have a fixed term agreement, you have to pay to the end of the agreement or 3 months, whatever is less remaining. So fixed term agreements, you really, if you use them, you need to either do them for a short duration, like a year, or make sure that you're going to keep that employee for the period of the term. Look, nobody likes to be fired. We always recommend structuring a termination as a voluntary separation. Why? It allows the person leaving to have dignity and honor in their exit. And I find 99 times out of 100, when you treat an exiting employee with respect, the process of termination is so much better than when you don't. So, an employee can be terminated without cause. You need to pay your end of service gratuity, your unused vacation, payroll, any benefit to return country, and additional compensation. And often we've seen, if there is an amenable exit, we want to avoid going to court, that the employer will offer between 1 and 3 months in recognition of this risk of arbitrary dismissal to go ahead and allow a way out for the employee. Again, given the cost and hassle of litigating these cases here, it's often makes sound commercial sense. I hate to say this as a lawyer, but it's better commercial sense to offer a severance package that gives you almost everything on it that you could get under statute than going through with a criminal, with a labor case. Pride is important. We discussed this. Allowing folks to leave with dignity, it reflects well on the business. It also reflects well on them. There are employees who will reject that, no matter how thoughtful the termination is. So when that happens, you have to be prepared to defend and to think about how to do that. Let's just talk briefly about the judicial process. First, before there's a complaint, before you go to court, the employee must go through either the Ministry of Human Resources or the relevant free zone authority to try to mediate the dispute before they file a formal claim. If you cannot successfully mediate it, the Mohre or the free zone will issue a reference to court. There's no court fees for employees filing below a certain threshold. And so it's often as an invitation for employees to file. I think, why not? I'll just roll the dice and see what I get. Almost always, courts are going to appoint an accounting expert that's from a roster of experts. and they will look at the facts of the case and issue a report that the court then uses to issue their decision. Talking about 3 to 6 months at the court of first instance, I've seen that go far beyond a year. I've had cases with complicated appeals to the Court of Cassation that can go up to 3 years. So this can be a lengthy and expensive process. So when do you settle? I think this is, your managing director is asking the in-house counsel, what do we do? You need to price in the cost of litigation. That's hiring a local litigator, having a firm like us involved in termination and advising, and see whether the costs make sense. It may make sense to offer the full package, i.e. everything that they could get under statute, because the cost of litigating in terms of time and hassle and money is not worth it. Again, sometimes you have to fight the claim. And we've seen instances where employees demand 2 or 3 or 4 times what they could possibly get under statute. It also may be that you want to set a precedent to your employees in your shop. Hey, we're not going to be blackmailed every time somebody leaves. So I think these are key things to consider. I would say that more often than not, and I would be interested to know your thoughts on this, more often than not, it makes sense to settle. It's only when you have an unreasonable employee that you're forced to move forward and to proceed. I'm sorry, in my haste, I missed this. We have questions for termination, and I'd be interested to know if we could, Rahul, go through these quickly, and then I think open it up for questions since we don't have a lot of time left.
Yes, absolutely. We have 2 minutes, so you will have to make it quite.
Let's do the poll, and then we'll go from there. So, who handles executive level terminations at your company? Is it HR, the general counsel, CEO, a combination, or somebody else? And then we're curious to know, in the UAE, are you more likely to settle or let them proceed to court? When you do have a high stakes termination, do you hire external counsel or do you manage it internally? Yeah, very interesting. So HR handles terminations 50% of the time. Others, it's a combination. I would assume that that's the PC and CEO and HR. Almost everybody says, let's settle. And I think I would agree with you, unless you really have to. Settling makes sense most of the time. And then final question here, who handles high stakes terminations? External counsel or internal? Slightly more internal, but some external. We find that our counterparts inside of a company are almost always very well able to handle these things, but it sometimes makes sense, especially when you have combative employees, to bring in external counsel to assist with this. Rahul, I think we've got some questions, and then I don't know if we want to just open it up to questions now.
We can answer one question because it's already time.
Sure. All right. So I think, please advise a calculation of gratuity should be based on 365 days a year or 30 days in a month. It's a continuous year. I believe it should be 365 days. We see this, we see people doing different calculations with 30 days. It generally is pretty minor difference. I would tend to go with what favors the employee if there is a discussion, so that you don't make a big deal out of a few hundred dirhams.
Brilliant. Well, thank you very much, Jonathan. I know we keep getting questions. It's a testament to your presentation and how important this topic is to in-house counsel and everybody who has joined today. So if you have any further questions, or if in case your question hasn't been answered, I'll share Jonathan's email in the chat function. You can always just Google Jonathan Noble AMERELLER and you'll get all the details right away. So Jonathan, thank you very much for that great, impressive presentation. And hopefully you'll receive a lot of emails from today's attendees asking you for, your slides and also more questions. We'll keep you busy.
Happy to be of assistance.
All right.
Thank you, everyone. Have a great evening.
Thank you so much. Now, that concludes our day, our presentation for for today. And what I just like to do is share some more information about the upcoming our upcoming presentations and our upcoming days. Let me just try to make this full screen. There you go. Right. So the second day of the UAE In-House Community Congress will take place on the 27th of September. That's also a Monday. We'll start at 3 p.m. The day will have 2 panel discussions. So we'll have the first panel discussion with lawyers from Al-Suwaidi and Company. The discussion will be around anti-money laundering legislation and dispute resolution in UAE. And post that, we'll have a GC and a partner discussion, and this will be about mental well-being and also diversity, equality, and inclusion. So these 2 panel discussions will take place on the 27th September. And then on day 3, we have 1 presentation, which would be from lawyers from Hardeep and Partners. And the topic would be about UAE intellectual property, and everybody will be able to get a good legal update of UAE intellectual property, and a lot of time for Q&A as well. Now, right after this webinar, we close this webinar at this event. It will take you to a survey. I really request you all to fill in the survey, which will pop up on your screen. It'll just take less than 2 minutes. It's very important for us that you provide your feedback to us on today's session. It enables us to create better experiences online and hopefully offline for you, and tells us what more do you need to know and what we can do for you. Right, so thank you very much for attending today's session, and we'll see you in the next one. Thank you, bye-bye.